So, uh, good morning, good afternoon to all of you. I'm Father Pudu, Professor of the Faculty of Canon Law here at St. Paul University, Ottawa. It is my pleasure to welcome the presenter, Professor Sunny Kokkaravalayil, Jesuit, and all the participants to our webinar organized jointly by our Faculty of Canon Law, the Canadian Canon Law Society, and the Center for Canonical Services. I'm happy to introduce the presenter of our webinar today, Professor Sunny Kokkaravalayil, a Jesuit priest from India who lives in Rome. He holds a licentiate and a doctorate from the Faculty of the East in Canon Law at the Pontifical Oriental Institute in Rome, where he has been teaching since 2005, becoming full professor in 2018. He was the acting dean of the same faculty from 2015 to 2016, and actually he is now an acting dean of the faculty. He is also the Vice Rector and Registrar of the Pontifical Oriental Institute from 2016. He teaches courses on Syro-Malabar legal sources, canons on the Institutes of the Consecrated Life, philosophy of law, and theology of law at Pontifical Oriental Institute in Rome. His publications encompass various aspects of the Oriental canon law, and one of his books is The Guidelines for the Revision of the Eastern Code, Their Impact on CCEO. Based on his vast experience in the field of Eastern canon law, he is presenting today's webinar on the revised penal law of the Eastern Catholic Churches and overview. Professor Sunny, welcome. Thanks a lot for accepting to present this webinar for our faculty. The floor is yours.
Good evening to all of you. This is evening here in Rome. I know that you are there in good afternoon. Okay, we shall begin immediately. The title of the paper is The Revised Penal Law of the Eastern Catholic Churches. Pope Francis promulgated the revised penal law of the Eastern Catholic Churches with the apostolic letter Vocare Peccatores on 20th March 2023, which obtained force of law on the 29th of June 2023. The immediate context of this revision was the revised penal law of the Latin Church, promulgated with the Apostolic Constitution Pascite Egregium on 23rd May 2021 and entered into force on 8th December of the same year. It was necessary to equip the Eastern churches with sufficient laws to meet their new needs, particularly in the light of the updated laws of the CIC. While the entire Book 6 of CIC is revised and promulgated through Pascite Egregium and Apostolic Constitution, only some selected canons were revised and promulgated through Vocare Peccatores and Apostolic Letter. In this paper, we shall make an overview of the changes made in the Eastern Penal Law. We include a brief study of the new norms in the light of the general principles of CCEO. That analysis can help in understanding whether the new laws align with the values originally enshrined in the CCEO. As the norms of Sacramentorum Sanctitatis Tutela apply also to the Eastern churches, it is useful to make a study on how the new norms are related to the norms of SST. While taking note of the substantial differences between the corresponding norms of the CCEO and of the CIC, we shall not address insignificant variations such as editorial differences and use of terms. We do not make a comparison between the former and the present Eastern Penal Law unless when it is necessary. Neither do we have any intention to make a commentary on the revised norms. In the presentation, we cover only the essential elements. I have also prepared a more comprehensive version of this paper for publication. Now we shall go to, we can make an overview of the revised norms. I shall show the slides. Okay, this is the first canon which is revised, that is Canon 1402, paragraph 1. This is entirely new. You see the extreme left table, the new...
Father Sunny, you have not shared.
Not shared?
Not shared.
Okay, what happened? Let me see, okay. Is it all right now?
Yes, yes, thank you.
Okay,
thank you.
Very, very good, thanks, thank you. Okay, you see 3 columns in the table. Extreme right, extreme left is the English translation of the CCEO norm. In the middle column is the Latin original of the CCEO norm, and on the right-hand side is the Latin parallel canon, the parallel norm of the CIC. Is that all right? Is it understand?
Thank
It's
you.
okay?
Yes.
Okay.
Yes.
Okay. So I shall make a brief presentation of this canon here. Canon 1402 has been changed mainly by adding its present first paragraph. This is the first paragraph which you see. Accordingly, the present version has 4 paragraphs. The revised norm makes it obligatory for the hierarch to initiate the procedure, to impose penalties if reprimand, entreaty, or rebuke proves insufficient to restore justice, to reform the offender, and to repair the scandal and damage of the delict. It expresses clearly the aim of imposing penalty, namely, bring the offender to repentance and to self-reform and repair the scandal and damage. In the concept of medicinal character of penalty, all these aims are included. You may know that in the Eastern penal law, the medicinal character of penalty has a key role. Okay, so here there is nothing significant. Here, this canon 1402, paragraph 3, there are only slight modifications. You see the red letters. Those red letters are the additions, the novelty. I don't explain that here. This is canon 1406. Here also there are only small additions. Okay, here there is something more important, 1407, paragraph 3. If warnings or reproaches have been given to someone in vain, the hierarch is to issue a penal precept in which he precisely prescribes what is to be done or avoided. This is the same as in the Latin canon law, so therefore it doesn't need an explanation. We shall go to 14, paragraph 1. This is an addition. The added paragraph states that anyone is deemed innocent until proven otherwise. This is also there in the Latin canon law, in the code, only to show that there are many similarities in the norms. So this also does not need any explanation. This 1416 paragraph 2 is new. This is previously this canon had only a single paragraph. In addition, a long clause is added to its present paragraph 1. Further, the previous potest has now become debet. Before it was the judge could, but now he should. The modification in paragraph 1 obliges the judge to impose more severe penalties than what is established in the law or precept, not excluding the penalties listed in paragraph 1402, paragraph 3. If a delicti has been committed by a recidivist or by one who is in a state of drunkenness or other disturbance of the mind that is intentionally sought out to perpetrate or excuse the delicti, or by one who acts due to willfully stimulated or stoked passion, the optional penalties can become obligatory. This is the same in the Latin Code. For 1429, this canon has undergone sufficient modifications which was not there previously. Its present paragraph 1 and 2 are new, which respectively make a list of prohibitions and prescriptions. These were not there before. There are 7 prohibitions and 2 prescriptions which can be imposed as penalties. This is taken mainly from the Latin Code. Okay, 36.3 is new. It prescribes punishing those who have recourse to the College of Bishops against an act of the Pope. This is somewhat similarly present in the Latin Code, but there is a distinction. The Latin Code, the Latin canon, has also prohibited or considers it a delict to make a recourse to an ecumenical council. CCEO appears to directly rely on the CIC's revised penal law for identifying new delicts. Nevertheless, the penalty prescribed for the same delict in both codes is not always identical. So, delict are more or less identical, delicts in both codes, but penalty is not always identical. There is substantial difference. We will explain that. The penalties prescribed in CCEO are more in tune with the fundamental outlook and orientation of that code, as we shall see below. Understanding certain similarities and dissimilarities between CCEO and CIC penal law. Okay. In this section, we shall take note of some striking similarities and dissimilarities between the penal law of CIC and CCEO. This observation can help us understand better the revised canons. A comparison of the parallel penal canons of CCEO and CIC reveals significant similarities in the list of delicts. Although this observation might lead one to suspect a Latinization of these Eastern norms, it would be more accurate to say that the revised norms of both codes share a common source. So the similarity could be attributed to their common source. In other words, they have been inspired by same features, same factors, which we may call generally the need of Eastern churches or the Latin church respectively. The changes in the CCEO canons were made not merely due to the revision of the Latin penal law, but were deemed necessary to address the contemporary needs of the Eastern Catholic churches. On the other hand, we can see that the new norms are generally in harmony with the vision of the Eastern Code and its basic principles. Having maintained the general terminology used in that code, the new norms use terms such as hierarcha instead of the Latin ordinarius, congrua pena, not justa pena, as in the Latin Code, delictum contra castitatem, not delictum contra sextum decalogi, as in the Latin Code, etc. So the Eastern norms use the same terminology which were already used by the Eastern Code. That is to say, although CCEO has received certain norms directly from CIC, it has not adopted the terms which are alien to it. Thus, we can say that the modifications in CCEO penal canons are integrated into the already existing frame, structure, terms, and canon numbers of that code. In that way, the revision has not disturbed the internal harmony of the already existing code. However, similarities in the penalties prescribed in both codes are less frequent. That is to say, CCEO and CIC do not always prescribe the same penalty for the same delict. We shall limit ourselves to an example. While Canon 1456 paragraph 2 prescribes an appropriate penalty not excluding minor excommunication or suspension for violating the confessional secret by a translator and anyone to whom knowledge of the sins comes in any way, its corresponding CIC, Canon 1386, paragraph 2, prescribes just penalty, not excluding excommunication. There is a notable difference between the minor excommunication of CCEO and the excommunication of CIC. Both these codes, these penalties are prescribed in these codes for the same delict. Those punished with a minor excommunication are deprived of the reception of the divine Eucharist. In addition, they can be excluded from the participation in the divine liturgy and even from entering a church if divine worship is publicly celebrated there. Instead, an excommunication according to the Latin norm imposes much more serious penalties, prohibitions, and it comes close to the major excommunication according to CCEO. This example illustrates that the penalty imposed by the Eastern and Latin codes for the same delict is not always uniform, and there can be significant disparities at times. The difference in the norms of Canon 1436 paragraph 3 and CIC Canon 1366 deserves our attention. While the former prescribes penalty for those who makes recourse against an act of the Pope to the College of Bishops, the latter prescribes penalty for those who make recourse to an ecumenical council or the College of Bishops. Does it mean making recourse to an ecumenical council is permitted for an Eastern faithful? It seems not. The College of Bishops is also the subject of supreme and full power, whether within or outside of an ecumenical council in the Church. Although conceptually an ecumenical council and the College of Bishops are distinct, an ecumenical council gathers the members of the College of Bishops. It is true that non-bishops could be invited to take part in an ecumenical council. Since the members of the College of Bishops are present in an ecumenical council, if a person makes the stated recourse to an ecumenical council, this act can be interpreted as making recourse to the College of Bishops. On the other hand, such a recourse may also be made to the College of Bishops outside an ecumenical council. Thus, actually, there is no need of specifically mentioning the ecumenical council in that canon. This is perhaps the reason for the exclusion of the term ecumenical council from Canon 1436, paragraph 3. While similarities between the revised Eastern norms and CIC penal law may imply the former's apparent reliance on the latter, Their dissimilarities serve as evidence that the Eastern penal law has not blindly adhered to the Latin code. Instead, the main concern of the Eastern Commission was to make laws in harmony with the nature and need of Eastern churches. We shall see that in detail in the following section. The section is the revised norms in the light of the general principles of CCEO. The preamble to the apostolic letter Vocare Peccatores can help us identify the intention behind the revision of the CCEO penal law, namely to adapt them to the pastoral demands or the present-day needs of Eastern churches. With the same purpose, the Pope revised also the Latin penal law. Pastoral demands or present-day needs are umbrella terms that can encompass various principles. The changes introduced by the revision are grounded in the founding principles of the Eastern Code, which are derived mainly from the teachings of Vatican II and the common disciplinary tradition of the Eastern churches. We can find two general principles underlying the canons of Title 27, namely, return to the ancient canonical sources of Eastern churches and respond to the present needs of Eastern churches. These principles were mandated by Vatican II. In addition, the Commission for the Codification of CCEO gave 10 guidelines, one of which was entitled Canoni de Delictis. These principles and guidelines fashion the spirit behind the CCEO penal law, which fact is reflected in its pursuit of values like justice, decision to exclude late sententia penalties, to give a canonical warning before proceeding to inflict penalty, to consider positive acts as penalty and penance, to emphasize on the medicinal character of penalties, to make space for possible reform of the offender, to uphold respect for human dignity, to apply the principle of subsidiarity, to make preference for a judicial process over an extrajudicial penal process, to safeguard the right of defense of the accused, to respect the offender's good reputation, etc. Even after the revision introduced by Vocare Peccatores, this spirit is generally preserved in the Eastern Catholic penal law, ensuring the continuity of its original character. In this section, we shall illustrate the application of this spirit. One of the overarching principles applied in the CCEO is justice, which includes various other principles such as preference for judicial process and the right to self-defense. We can confidently say that this principle is highly respected also in the revised norms. It is evident from the concern to punish only those proven guilty and to impose punishment in proportion to the gravity of the delict. For this purpose, the code employs various mechanisms such as rigorous law, strict interpretation of penal law, and the possibility of appeal or recourse. The newly added norm that one is presumed innocent until the contrary is proven strengthens this principle. Thus, we can affirm that the new law is vigilant in its pursuit of justice. An examination of the revised canons in the light of the above mentioned guideline, Canoni de Delictis, will reveal that its recommendations are respected also in their revision. No late sententia penalties are prescribed for any delict, also in the revised norm. When a faithful subject to CIC can be punished with such a penalty, his or her brother subject to CCEO cannot be punished with it, although they may have committed the same delict. Penalties are imposed after warning the offender at least once, and when warnings and reproaches have proven unsuccessful in preventing the delict. This principle makes imposition of penalty as the last resort to remedy a delictual situation. The new canons adhere to CCEO's policy, which views a penalty as both a privation of good and an imposition of positive acts. The medicinal character of penalty of the Eastern Code sets the key of interpretation of the penal canons, which remains the same even in the revised canons. The respect towards this character is visible basically through excluding the late sentencia penalties by leaving ample space for the discretionary power of penalizing authority and the judge, etc. All these norms are maintained even after the revision. Canon 1401 insists on healing all wounds, not only of the offender, but also of the community which is wounded by the delict of its member. The legal principle nulla pena sine lege penali, although not explicitly invoked, is strongly present in CCEO, especially with its Canon 1414, paragraph 2. The revised law also respects this principle by not incorporating a law parallel to CIC Canon 1399, the last canon of CIC penal law. In this regard, it is useful to make a study on why a similar canon was not included in CCEO. During the codification of CCEO, a new canon was added to the schema which would provide for penalizing an offender with a just penalty for an external violation of divine or canon law, considering the gravity of the situation and the scandal, even if the present penal law does not foresee that delict or its penalty. At the end of a long discussion, the Commission decided not to include this proposed canon. About this canon, the Cetus has entered, it's a citation, about this canon, the Cetus has entered into a long discussion because of the well-known implication regarding the principle nulla pena sine lege vel precepto penali previo. The absence of such a canon in CCEO is significant because it implicitly says that if somebody does not violate a penal law or a penal precept, he or she cannot be canonically punished. One of the concerns of the CCEO Codification Commission was to make laws useful for the present needs of the Church, which concern is expressed in the above mentioned guideline, Canoni Delictis. According to this guideline, the return to ancient tradition, although very important for the Eastern churches, should not be the only concern of the Commission, and such a return is not conceived at the cost of the Church's present-day needs. One of the reasons to avoid late sentencia penalties in the Eastern Code was that they did not seem necessary for the purpose of the adaptation of the Oriental Code to the present-day requirements of the discipline of the Oriental Catholic Churches. Thus, the present-day needs of Eastern churches was a criterion in determining the penal laws in CCEO. The Codification Commission received laws mainly from the Eastern traditions. However, when certain Latin law was found useful to meet the present-day needs of the Eastern churches, they also were received. The same spirit is reflected behind the reception of the new penal law from the revised Latin penal law norms. Promulgating Vocare Peccatoris, Pope Francis says, the need to adapt the instruments of governing to pastoral demands has led in recent years to start the study for the revision of the penal system in the Church. As a result of this commitment, I modified the Latin canonical penal norms with the Apostolic Constitution Pascite Egregium Dei. In the same way, I now wish to introduce similar modifications also in Title 27 on penal sanctioned in the church, and in Canon 1152 on prescription of penal actions in the Code of Canons of the Eastern Churches, so that the Eastern penal discipline may be more suitable and effective for today's needs of the Eastern Catholic Churches and is in harmony with the universal discipline. If the needs of the Eastern Churches did not demand those new laws would not have been made. This means the aim of the promulgated penal law is to make them suitable and effective for today's needs of Eastern Churches, a criterion which CCEO followed at the time of its codification and which is followed also for the revision of its penal law with vocare peccatores. There are also values like human dignity, respect for human dignity in the revised norms. Just a point about the double fidelity. What is that? Presenting the Eastern Code to the Synod of Bishops in Rome on the 25th of October 1990, Pope John Paul II speaks of a double fidelity. We also give expression to our hope, already expressed in June 1986, that the code just promulgated, that is the Eastern Code, the venerable churches of the East can recognize not only their traditions and disciplines, but also and above all their role and their mission in the future of the universal church and in the extension of the kingdom of Christ Pantocrator. And that this code may truly be a vehicle of charity in the service of the church. In these words, the Pope identifies a double fidelity of the Eastern churches, namely to their traditional discipline as well as to their mission in the present and future. An overview of the revised norms in the light of the general principles of CCEO reveals that, on the whole, this revision in the penal law takes into account this double fidelity. Although the Eastern penal law was revised in the context of the revision of the Latin parallel, it is not a mere copy. Instead, the present Eastern penal law is adapted to the general framework of the Eastern Code. Several canons add a modification to highlight the need of reform of the offender, restoration of justice, reparation of the scandal and damage made by the delict. The preamble of vocare peccatores presents this need as the aim of canonical penalty. This highlight is significant as it emphasizes that the sole purpose of the penalty is not only the reinstatement of the offender. The present emphasis underscores the equally crucial aspect of focusing the restoration of justice to the victim through the repair of scandal and damage. This was present in the previous law, but not very explicit. But today it is more explicit. The victim-centered law also. The emphasis on the restoration of justice also to the victim. This understanding corrects the commonly held impression that the penalty is a medicine for the offender alone, which impression was not really shared by the penal law of CCEO even before its revision. However, there are also instances in which the present Eastern penal law has slightly deviated from certain principles applied in the original penal law of CCEO. It is useful to note that the revision has slightly reduced the space for particular law in CCEO. The guidelines for the codification of CCEO emphasized that the Eastern Code should be limited to the law common to all the Eastern churches, allowing each church ample freedom to make and codify its particular law. In accordance with that policy, the previous CCEO penal law did not contain a norm for punishing the trafficking of the mass stipend although the previous CIC Canon 1385 dealt with this matter. In fact, a norm was proposed to be included in the previous Eastern penal law, but it was not accepted because the norm on mass stipend were different in various churches, and if a church wished to make a law on that matter, it could do so in its particular law. So in the previous penal law, this matter was left to the particular law. But in the present, the revised present Eastern penal law includes that norm in the common law, in CCEO. By providing a law among the present penal law, it has not respected that provision for particular law. Similarly, when there was a suggestion to incorporate in the previous Eastern penal law detailed norms on the attenuating and aggravating circumstances of a delict, it was rejected, saying that a common code of the Eastern churches should not contain detailed norms which should be left to the prudence of judges. But Canon 1416, paragraph 1, now includes detailed norms regarding the aggravating circumstances against the intent of the codifying fathers. These examples show that the space which CCEO originally left for particular law is reduced in the newly revised penal law. Certain matters which the CCEO Codification Commission deliberately left out are included among the revised norms. I shall just briefly say it. Previously, there was only a norm on the simulation of sacraments. There was no norm against the delict, explicitly against the delict of attempting a sacrament. They did not want, it was proposed, but the previous Codification Commission did not want to include a norm on that, but instead of that, they said the codification, it was provided for, attempting also was provided for by the previous Canon 1443, which provided for the delict of illegitimate performance of any priestly action or another sacred ministry. So in that provision, attempting of a sacred function or a sacrament was included. But now there is a new norm on delict against attempting also. Thus, in general, we can say that the new penal law norms adhere to the vision and principles of penal law originally contained in CCEO. However, at times they have deviated from that vision and those principles. A short description about the relationship between the new norms and the Sacramentorum Sanctitatis Tutela. I want to highlight only 2 points. One is, previously, the Eastern Code prohibited the imposition of certain penalties by extrajudicial decree. They could be imposed like privation of office, title or insignia, a suspension for more than 3 years, demotion to a lower grade, deposition from priestly ordination, and major excommunication. These could be imposed only after a judicial process. However, this prohibition is not applicable to the delicts mentioned in the Sacramentorum Sanctitatis Tutela. Also, these penalties could be imposed by an extrajudicial decree issued by a competent authority having obtained the prior mandate of the TDF. Another difference is there is a notable difference between 2 canons of this. I think I have to show you. 1453 paragraph 1. Yes. Are you showing? Can you all see this? 1453.5 Eastern Code and Canon 1398.1. Okay?
Yes, we can see it.
You can see that. Okay, very good. What you see in red letters are the differences. I shall read it. Privazione officii et aliis congruis pone non exclusa depositione, si casus id circumferat, puniatur clericus, qui delictum committit contra castitatem cum minore vel cum persona, que habitualiter usu rationis caret, that red thing, red clause. That is the expression in the Eastern norm. Whereas in the Latin norm, the expression corresponding to that is habitualiter usum imperfectum rationis habet. So this imperfectum rationis habet is not there in the CCEO, but in the CCEO, the verb used is caret. There is a difference. This is consistently used in the whole three times used in the CCEO and 3 times used the same expression in the CIC also. We shall explain this difference. These CCEO and CIC norms deal with the same matter. However, the use of terms habitualiter usu rationis caret in CCEO and habitualiter usum imperfectum rationis habet in CIC makes a notable difference. In the former case, one can be considered a victim only if he or she habitually lacks the use of reason. In the latter case, one can be considered a victim if he or she has habitually an imperfect use of reason. That is to say, a faithful subject to CCEO should completely lack the use of reason to be a victim, but one subject to CIC can be considered a victim even if he or she has partial use of reason. It is enough that its use is imperfect. Canon 1453 paragraph number, as a norm prescribing a penalty, is subject to strict interpretation. Such an interpretation will clearly highlight the distinction between the lack of the use of reason of the victim and his or her imperfect use of reason. This is a notable difference. This goes in favor of the offender, not of the victim, subject to CCEO. It is not a question of a different formulation or use of distinct terms, but makes a difference in the essence of the norm. Since this term is consistently used in the revised penal law of CCEO, we cannot consider it an oversight. At the same time, it is not clear why such a notable distinction is made between the two codes. Sacramentorum Sanctitatis Tutela uses the CIC term. Okay. Sacramentorum Sanctitatis Tutela does not prescribe any late sententia penalty for the subjects of CCEO, but it does for those of CIC. The reason is SST's respect for the general principle of CCEO to avoid such penalties, which says that a penalty is to be imposed by a sentence or a decree. We can come to the conclusion. Ongoing evangelization includes a continuous reform of the church's law to help the faithful to practice Christian love effectively. Changing circumstances create new needs which may require new norms or updating the current ones so that the gospel teaching can be continually presented in a relevant manner in the life of the church. Placing himself within the horizon of this vision, Pope Francis decided to revise certain canons of CCEO. Those canons belong mainly to Title 27 of the Code on penal sanctions in the church. However, the majority of canons of that title remains unchanged. Canon 1152, which is outside the Title 27, is also revised to harmonize it with the changes in the penal law. The revision addresses the identified limitations of the previous Eastern Catholic legislation on penal sanctions. I come to the end of the conclusion. In continuity with the general canonical system, and in particular with the penal law of the Eastern Code, the revision introduces provision to deal with certain new delicts to address the growing need of the Eastern Catholic Churches, to ensure the restoration of justice, the reform of the offender, and the reparation of the scandal and damage. In short, the common good of the Church. Thus, the revision of the penal law of the Code of Canons of the Eastern Churches corresponds to the need of the time and is coherent with the current Eastern canonical system, and in particular with the spirit of the penal law of those churches as envisaged by the codifiers of the Code of CCEO. Thank you very much. I just want to say a word of thanks to Father Pudu, Sister Louise, and all the other organizers and the audience today for having listened to me and having given me this opportunity and honored me in this evening. Thank you very much.
Pastor Sunny, thank you. Thank you for sharing with us your profound expertise in this area of canonical importance regarding the Eastern canon law and the renewed penal law in CCEO. Your insights have helped us to better understand various changes, perspectives in this important aspect of recent renewal of the Eastern canon law. Thanks so much for taking your time. May God continue to bless you in all your endeavors. Thank you. A big thanks also to all the persons at St. Paul involved in the preparation and conducting of this session, especially the members of the coordinating team. Along with me, our faculty's Dean, Professor Chad Glendinning, representing our Canadian Canon Law Society, Sister Louise Charbonneau, Administrator of the Center of Canonical Services, and Mrs. Ruth Burrow, Assistant to the Dean and Program Coordinator. Finally, a special thanks to all of you, the participants in this webinar, either live or offline. We are truly grateful to you that by your presence you support our initiatives and thus encourage us to continue. Please do remember to register also for our last webinar of our academic year on the topic Practical Guidelines for Aging Religious Institutes by Sister Amy Hereford on 24th April 2024. Thanks again and goodbye. God bless you all.